inform you that our tables are equipped with interpreting devices. For English, you can press channel 1. For French, you can press channel 2. For Arabic, you can press channel 3. For Portuguese, you can press channel 4. And for Russian, you can press channel 5. Ladies and gentlemen, please be seated. Thank you. We will begin our event shortly. Ladies and gentlemen, please be seated. Our event will be opening shortly. Good morning, Excellencies, distinguished delegates. Ladies and gentlemen, welcome to the Aacc CCJA Joint Conference. My name is Wahyu Iwoho. Allow me to begin our conference with remarks from the Chief Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Anwar Usman.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Yang saya muliakan, Presiden Conference of Constitutional Jurisdiction of Africa, CCJA. Yang saya muliakan, Presiden Mahkamah Konstitusi atau lembaga sederajat yang berada dalam naungan organisasi CCJA. Yang saya muliakan, Presiden Mahkamah Konstitusi atau lembaga sederajat yang berada dalam naungan organisasi Aacc. Hadirin para delegasi yang juga saya muliakan. Pertama-tama, perkenankan saya mengucapkan selamat datang di Pulau Bali yang indah, pulaunya para dewata, pulau yang telah menjadi destinasi wisata bagi para wisatawan dari berbagai negara di dunia. Semoga dengan diselenggarakannya pertemuan Aacc dan CCJA di Pulau Dewata ini dapat melahirkan inspirasi yang bermanfaat untuk kebaikan kedua organisasi dan bermanfaat pula bagi seluruh bangsa di dunia. Hadirin yang saya muliakan, ikhtiar untuk membangun jalinan kerjasama antara Aacc dan CCJA telah dilakukan sejak tahun 2016. Ketika itu, Mahkamah Konstitusi Indonesia diketuai oleh Yang Mulia Profesor Dr. Arif Hidayat, SHMSI, dan telah melakukan pertemuan dan pembahasan tahap awal tentang rencana dibentuknya konferensi bersama antara Aacc dan CCJA. Lalu pada tahun berikutnya, tepatnya tanggal 9 Agustus tahun 2017, nota kesepahaman antara Aacc dan CCJA ditandatangani. Hari ini merupakan kegiatan pertama antara Aacc.
Today is the first activity, which is the joint conference. This is to remind us that the initiation of the joint congress between AACC and CCJA was inspired from the historic moment of the relationship between Asian countries and the countries in Africa in the past, with our commonalities and emotional ties. Therefore, we bound ourselves together within a conference which we know as the Asia-Africa Conference. At this moment, the challenges faced by Asian countries and the countries in Africa are, of course, different compared to the time when the Asia-Africa Conference was established. Challenges both internal or national, as well as external or international, these are efforts to overcome the challenges, including in applying the principles of rule of law in our nationhood and statehood. The Asian and African countries follow the principle of local countries in the management of the state. One of the principles of the state is we are independent and impartial. In this situation, the cooperation between AACC and CCJA is relevant.
Sebagaimana kita ketahui bahwa salah
As we
satu
all
kriteria
know,
konsepsi negara hukum
one of
adalah
the subjects
adanya
of a
perlindungan
country of
penuh
the rule of law
terhadap
is a
hak
guarantee of
konstitusional
protection
warga negara
for the
atau hak
constitutional rights
asasi
of the
manusia
citizens
yang harus
or human
dipenuhi
rights,
oleh
which
negara.
must be fulfilled by the
Hak
state.
konstitusional warga negara
The
harus
constitutional
dijamin
rights of
oleh
citizens
konstitusi
must be
negara
guaranteed
dan harus
by the state's
dipenuhi pula
constitution
oleh
and must
negara.
also be fulfilled by its
Sedangkan
state.
hak asasi manusia
Meanwhile,
harus
human
dipenuhi
rights
oleh seluruh
must be fulfilled
negara-negara di dunia.
by
Karena
all
hak
states in
asasi
the
manusia
world because
sebagaimana
human
telah
rights,
dideklarasikan
as
dalam
declared
Deklarasi Umum Hak
through
Asasi Manusia Universal
the Universal
Declaration of Human
Declaration of
Rights
Human
tahun
Rights in
1948 oleh
1948
Perserikatan
by
Bangsa-Bangsa
the United
telah menjadi
Nations
standar bersama
has become
bagi
the common standard
bangsa-bangsa di dunia.
for all the countries in the
Namun,
world.
seiring
However,
dengan berkembangnya situasi global
with the development of
dan
global
perkembangan di era
situations
teknologi
and the
industri
developments in
yang
this
demikian cepat,
technological industrial
pemenuhan terhadap
era,
hak asasi
which
manusia
is very
tidak hanya
rapid, the
bergantung
fulfillment
kepada
of human rights
negara
do not
semata,
just depend solely
melainkan
on the state, but
juga
rather
oleh perusahaan-perusahaan
by
multinasional
multinational corporations,
yang memungkinkan
which
untuk diabaikannya pemenuhan
means
hak asasi
the fulfillment of
manusia.
human rights may be neglected.
Semisal
For example,
eksplorasi alam yang
exploration of
merusak
natural
lingkungan
resources which damage the
seperti
environment,
pertambangan,
such as mining,
penebangan hutan, dan sebagainya.
logging of
Hal
forest,
tersebut
and
tentunya
others.
dapat saja mengabaikan
These
hak-hak masyarakat
may
yang
ignore
terdampak
the
dari
rights
kegiatan
of
tersebut.
communities impacted by these
Jika terjadi
activities.
kondisi demikian,
Should these conditions
maka
occur,
bisa menjadi otoritas Mahkamah
it
Konstitusi
may be within the authority of the
menerima
Constitutional Court
pengaduan konstitusional
to accept
atau judicial
constitutional
review
complaints
atas
or judicial
mengeksekusi
reviews
undang-undang yang dapat merugikan
for the
warga negara.
implementation of laws which may be detrimental to
Saat
citizens
ini,
of the state.
perkembangan dunia
At this
digital
moment,
yang
the
demikian
development of
pesat
the digital world,
sehingga kerap
which
mengabaikan
is
perlindungan data
extremely rapid,
pribadi,
often
kebocoran
ignores the
informasi,
protection of
dan
private
data pribadi
data,
seseorang, tentunya
and
merupakan suatu pelanggaran terhadap hak pribadi
this is
seseorang
indeed
yang menjadi
an
bagian
infringement on
dari
personal
hak
rights,
asasi manusia.
which is part of human
Begitu
rights.
pula halnya tentang pemanfaatan dunia digital dalam berbagai
The,
sektor dan
this also applies
usaha
to the utilization of
pula
digital technology in
dalam
different
pelaksanaan putusan
business spheres,
yang kadang-kadang
and also
mendapatkan
the implementation of
resistensi
rulings,
dan
which
intervensi
is
dari
met
berbagai
by
pihak
resistance and
menjadi
interference by various
bagian
stakeholders,
dari
becomes part of
diskursus yang
the
harus
discourse
dapat didiskusikan
which
oleh
must be
kita semua.
discussed by us
Termasuk
all, including
perkembangan terakhir
the
yakni
latest developments,
kondisi regional tertentu
which is the
yang masih
particular regional
dilanda
conditions
konflik dan
which
perang
is overcome with
memberikan
conflict and
dampak yang
war.
serius terhadap
This has a
dunia
serious
global.
impact on the global
Untuk itu,
condition.
melihat
Therefore,
perkembangan dan pesatnya
observing
perkembangan di
the
tingkat global,
rapidity of global
langkah
developments,
bersama
the joint
antara
forum between
Aacc dan Ccja
AACC and
menjadi
CCJA
suatu forum yang
is a
strategis di tingkat
strategic
global
forum at the global
dalam
level
rangka mempromosikan
in order to
perdamaian,
promote peace
perlindungan tentang hak
and the
asasi
protection
manusia
of human
demi
rights
kebaikan bersama
for the sake of
seluruh
us all,
umat manusia.
for the sake of humanity.
Lalu di masa yang akan datang
And in the future,
perlu untuk
it is
dipikirkan
necessary
pembentukan sekretariat
to
bersama
establish a joint
seperti
secretariat
Aacc dan CCJA
for the forum of
dan
AACC and
kita dapat
CCJA to enable us
berkomunikasi
to
dan
communicate
berinteraksi
and to
dalam
interact
menyikapi perkembangan
in
global
taking
yang
a position
demikian cepat.
to the rapid global developments.
yang dapat saya sampaikan.
That is
Terima
all
kasih atas
I would like
kesempatan
to deliver at this point.
dan
Thank you
kehormatan yang
for
telah
the
diberikan
opportunity and the
kepada Mahkamah
privilege afforded
Konstitusi Indonesia
to the Constitutional Court of
untuk
Indonesia,
memfasilitasi forum yang terhormat
allowing us to
sehingga
facilitate this august
hubungan baik
forum.
dan kerjasama yang telah
We hope
terjalin
that the good
antara
relationship and
AACC
cooperation
dan
established between
CCJA
AACC and
serta
CCJA,
sesama
as
Mahkamah
well as
Konstitusi
amongst
maupun lembaga seperati
constitutional
di
courts
seluruh dunia
and
dapat
equivalent bodies
terjaga
across the
dan
world, may continue
ditingkatkan di masa yang
and be
akan datang
further improved and enhanced in the future.
atas segala kekurangannya.
I apologize for any
Wabillahi taufiq wal
shortcomings.
hidayah.
Religious
Wassalamualaikum
greetings, peace be
warahmatullahi
upon us all.
wabarakatuh.
Thank you, His Excellency Anwar Usman, the Chief Justice of the Constitutional Court of the Republic of Indonesia. Excellencies, distinguished delegates, ladies and gentlemen, next we present you a video of the cooperation between AACC and CCJA, which has been prepared especially for you.
Indonesia hosted the historic Asian African Conference from April 18th to the 24th, 1955 at the Merdeka Building in Bandung. The conference aims to enhance solidarity among Asian African nations to promote economic, political, and cultural cooperation. 29 countries attended the Asian African Conference in the spirit of decolonization with a determination to fight discrimination and racism. The conference was a significant step toward the eventual formation of the non-aligned movement and its advocacy for global peace and human rights protection. Based on mutual interests, the conference adopted the 10-point declaration, Dasar Sila Bandung, which promoted the advancement of global peace and cooperation. The Asian African Conference led to the creation of other conferences, such as the Asian African Journalist Conference, the Africa-Asia Islamic Conference, the Asian African Student Conference, and the Asian African Parliamentary Conference, which took place on April 23, 2015 at the Parliament Building. 33 countries from Asia and Africa attended the event. The momentum in 1955 and 2015 exemplified the long history and rich tradition of cooperation between Asian and African nations. Continuing in the spirit of the Asian African Conference of 1955, in 2017 in Solo, Indonesia, as the president of the Association of Asian Constitutional Courts and Equivalent Institution, AACC, initiated a cooperation with the Conference of Constitutional Jurisdictions of Africa, CCJA. The Memorandum of Understanding was signed by Chief Justice Arif Hidayat from Indonesia and from South Africa. This AACC-CCJA meeting is held at the same time as the 5th Congress of the WCCJ in Nusa Dua, Bali, Indonesia. The AACC and CCJA are committed to working together to build institutional capacity for the exchange of ideas and information, as well as to contribute to constitutional supremacy in accordance with their roles and authorities. So, what will the AACC-CCJA meeting deliver?
Right, ladies and gentlemen, let us move to the next agenda. We will hear remarks from the President Emeritus, Special Representative of the Venice Commission, Mr. Gianni Buchicchio. Without further ado, I would like to invite Mr. Buchicchio to deliver his remarks.
Monsieur le Président de la Cour constitutionnelle d'Indonésie, Madame la Présidente de la Cour constitutionnelle d'Angola, Mesdames et Messieurs les Présidents et les juges des cours et conseils constitutionnels, Messieurs les secrétaires généraux des deux associations, Monsieur Laraba et Monsieur Amaza, Mesdames et Messieurs, croyez-moi, je suis vraiment sincèrement heureux d'être
I am
ici.
sincerely happy to be here in your presence, to see so many friends that I haven't seen for many years. I am a man of a certain age, and I think you'll believe me when I say that I have suffered greatly of these past 2 years of pandemic, which prevented us from meeting each other, to see each other and to chat, to discuss. There were meetings, of course, thanks to Zoom or Google, that allowed us to exchange our points of view, but that prevented having the personal contact. Now, we have another system, a very efficient one, which has been developed and will develop more in the months that will come. This new system will allow virtual meetings like with Zoom, but you will also have the personal contact with some participants. For example, will allow us to have discussions between 2 or 3 people. Technology will never stop. Once again, I am very happy to see you in person, and I will try to participate in this joint conference, this 5th Congress of the World Conference of the Constitutional Courts. This will allow us to talk to each other, exchange, and carry out what we call cross-pollination of ideas and points of view. I'd like to tell you that based on my experience of several decades, that the conferences and seminars and symposiums, whether it's regional or global, they're very useful from these as great events. But the most important is the direct contact that we can have during these meetings. Why was I invited? I'll tell you a few words. I think we know that I personally, as a president of the Venice Commission at the time, I was there in the beginning of these 2 associations, with the Association of the African Courts. It was on the margin of the World Conference in Rio de Janeiro in January 2011. I was president of the Constitutional Court of Algeria. So I was told that we wanted to have a meeting on the side with the African countries to have a dream, to make come true his dream of the constitutional courts getting together around Africa. So that was done. And several African countries participated in this conference in January 2011 and showed their support of this initiative. Now, here's the interesting thing. When these initiatives need time, but thanks to the great willpower and helped by the Secretary General at the time, who is here today, Musa Walaba, In a few months, in May 2011, the conference of the Constitutional Courts of Africa had a General Assembly. It took only 4 months. Since then, this association has developed greatly. I don't know how many members are there now, but I would like to congratulate the association of all these countries for becoming members. In 2013, during the seminar of Cotonou, we signed an MOU allowing to maintain relationships, close relationships, and between the conference and the commission, this closeness, personal closeness, I would say, that I had with the constitutional courts of Africa, and the same is for the courts of Asia. I remember in 2005 at Ulaanbaatar, during the seminar organized by Mongolia, we had this idea to create an association of the constitutional courts of Asia. It took some time, for example, compared to the African countries, but things went forward thanks to the willpower of the constitutional courts of Korea, first of all, but also I remember the other courts, the Constitutional Court of Indonesia and of Turkey. So it was in Seoul in 2012 that finally, after several meetings that took place in Korea in 2012, the association rules were adopted. Then we set up a MOU with the Venice Commission, same thing as we did with the constitutional courts of Africa, and it allows the cooperation, and I'm sure this cooperation will continue. So it's a pleasure to see you all here together to talk of these fundamental matters of human rights. In Africa, you already have created a protection mechanism of these rights, and I congratulate you for this. This mechanism of protection of the rights has already been launched by the Korean Constitutional Court. Maybe this will come back, and you can talk about the usefulness of such a mechanism to protect of all your citizens in Europe, in Africa, in the Americas, and of course in Asia. So, ladies and gentlemen, I can confirm that the Venice Commission will continue to invest alongside you to help in the pursuit of our objectives. Thank you for your attention, and may peace be with you. That peace may be between all of our countries. Thank you.
Thank you, Mr.
Merci, Monsieur Januki, pour vos remarques. Mesdames et Messieurs, Excellences, chers délégués, nous arrivons à notre agenda principal, programme principal. Nous avons 2 sous-thèmes. Le premier sera la constitution de juridiction et la protection des droits principaux ou fondamentaux, des regards croisés de l'Afrique et de l'Asie. Ensuite, c'est aussi pour voir ce qui a été fait à Bandung pour l'Asie et pour l'Afrique. La discussion sera modérée par Monsieur Moussa, secrétaire général. S'il vous plaît, Monsieur Moussa Laraba, je vous invite à monter sur le podium.
Can I begin? It's okay? Thank you. بسم الله والصلاة والسلام على رسول الله. السلام عليكم ورحمة الله وبركاته. في البداية قبل أن أبدأ أريد أن أترحم على جميع الضحايا الذين سقطوا في الحادثة الأخيرة وأقدم كل التعازي والمواساة والتعاطف لأهلهم وأسرهم والشعب الأندونيسي بصفة عامة. في البداية أود أن أتقدم بشكري وامتناني لرئيس المحكمة الدستورية في أندونيسيا وقضاتها وجميع العاملين فيها على حفاوة الاستقبال وكرم الضيافة وأن أهنئهم.
Chief Justice of the Constitutional Court of Indonesia and distinguished audience, thank you for all the efforts that you have exerted to improve the cooperation between the constitutional courts and jurisdictions, Asia and Africa, inspired by the Bandung Conference and after the issuance of the Bandung Declaration to improve the cooperation between countries based on the UN Charter. Again, Indonesia has hosted a conference, but the message is going to be slightly different. The first time I met His Honor Anwar Usman and Arif Hidayat, he offered or proposed this idea to the Algerians. It was a simple idea, but with great impact because they were relying upon a great heritage, and he said that our ancestors and forefathers and mothers have produced the Bandung Declaration rather. Why can't we organize a similar conference? However, one that is based on or looking at the theme of constitutional justice in Asia and Africa. It is a good thing that we can do that and they can witness what we have organized. We now see that that idea has now become reality, and it was preceded by the signing of the MOU in 2017 that has allowed us to be together here to reiterate our commitment to realizing the idea. The meeting was supposed to be held in 2019, but because of the corona pandemic, we experienced a delay. but it is good that we are here now, and without we express our gratitude to the Secretariat and the continuous effort from the Indonesian Constitutional Court and the Algerian Constitutional Court as well, reserving no effort in organizing these events. In this meeting, for the first session, we will be talking about human rights and looking at ideas from Africa and Asia. The sub-theme 2 is the actualizing the Bandung principles on equality of all peoples. And that is why I am very happy to invite both speakers of this session, both from Indonesia and from Algeria.
My President, how are you?
Nice teaching you.
It's okay? إذن قبل أن أحيل الكلمة إلى سعادة المستشار عارف هدايات الذي كان له الفضل والسبق في المبادرة بوضع الأسس.
Before I hand over to the Constitutional Court of Republic of Indonesia, allow me
إذن معذرة لمعالي رئيس الأرسلان.
Speaker apologizes. Chief Justice, according to the program handed to me, this first session is with two speakers, Professor Dr. Arif. So I would like to welcome Mr. The Constitutional Court, Chief President of the Turkey Constitutional Court, Your Excellency Arif Hidayat. I would like to remind you regarding, I would like to talk about his CV. He's a professor, Constitutional Court, University of Diponegoro, from 2007 to 2011. He held position as a judge and also lectured at the postgraduate program. He's also the head of the lecturers organization and also held position as constitutional justice for 2 periods. He is a deputy Chief Justice, and Your Excellency, the floor is yours. You have 15 minutes. Religious greetings, peace be upon us all.
Good morning. Peace be upon you and your word. Your Excellency, President of Aacc, Your Excellency, President of CCGA, the Honorable President of Constitutional Court and equivalent institution within Aacc and CCGA, and distinguished ladies and gentlemen. I apologize that my speech would be in Bahasa instead of English, but we already provided that the translation on your desk. Sebagaimana yang telah disampaikan oleh
As already mentioned
Bapak Ketua MKRI Profesor
by
Usman, kemudian
the Chief
dilanjutkan
Justice
oleh
of the Constitutional Court,
Profesor Wijijio,
Anwar Usman,
Presiden
and
Commission,
Professor
dan disampaikan
Uchichio,
oleh
the President,
Dr.
Emeritus Professor of Venice Commission, and as stated by the moderator,
Masih jelas
Mr. Musa
didominasi
Laraba,
gambaran sejarah
it is still
mengenai
clear,
bagaimana
the
suasana
historical image is clear
sangat luar biasa
regarding the
bagaimana
extraordinary atmosphere and
Asia
enthusiasm
ketika
of the
menghadiri
Asia and African
Asia Asia
countries
Afrika
when
yang
attending
berjalan
the
di
Asia
Bandung
Africa
pada tahun
Conference, which was
1955.
held in Bandung
Betapa
in
monumentalnya
1955.
kehadiran 29
How
negara
monumental the presence
pemerintahan di
of
Asia
29 heads
Afrika
of states
saat itu.
and governments from Asia and
Negara-negara
Africa at that
yang
time.
mayoritas belum
Countries,
merdeka dari penjajahan,
the majority
negara-negara
of countries had only recently became independent from
imperialisme,
colonialism. Countries that dare to stand up to colonialism and imperialism, countries that aspire to world
negara Asia
peace.
Afrika itu
The
dilandasi
presence
oleh
of the leaders of the Asian African countries were
suci
based on
penghormatan
the
kedaulatan
sacred
negara,
spirit
kesetaraan
of respecting
dan
the sovereignty of the
kebesaran
state,
untuk mewujud
equality, and the
solidaritas
grand
dan
desire
kekuatan bersama
to weave
untuk
together
menghadapi
solidarity and mutual
tantangan
strength
global pada saat itu.
to face global
Semangat itu
challenges of that
masih
time.
relevan digaungkan,
This spirit
terus
remains
dilemahkan,
relevant.
dan harus terus
It is
dilanjutkan.
echoed
Pada titik
and
inilah
must continue.
Mahkamah Konstitusi
It is
Republik
at this
Indonesia
point that the
sebagai
Constitutional Court of the Republic of Indonesia,
mengajak seluruh
as a
peserta
member
AACC
state of
dan
the AACC,
CCJA
invites
untuk
all members of
melaksanakan
the
dan
AACC and
mengapresiasi
CCJA to hold this joint
mengapresiasikan
conference
semangat
to
pdi
actualize the
perjuangan
spirit
konferensi Asia Afrika
of the
yang telah
struggles of the
direalisasi
Asian African
Presiden
Conference. Your
CCJA
Excellency, the President of
dan
AACC, the President of
ibu-ibu
CCJA,
hadirin yang
the chairs of the
berbahagia.
delegation, distinguished guests,
Tantangan global
ladies and
yang dihadapi
gentlemen.
saat ini tentu
The
berbeda
global challenges we face
dengan
today
konferensi
are
Asia Afrika
certainly
diselenggarakan.
different
Hari ini
from when the
tahun
Asian African
2019
Conference was held. Today, that challenge
lingkungan dan
has come a long
ekosistem
way.
ekonomi politik, hukum,
The world's
dan
economic,
sosial dunia
political,
saat ini
legal, and social
semakin
environment and
kompleks.
the ecosystem today are increasingly
Dengan
complex,
lompatan perkembangan teknologi yang
along with the
tajam
leaps of digital
yang membuat
technology,
perubahan terjadi sangat cepat
which
di
makes
berbagai
for
bidang
very
kehidupan
rapid
manusia.
changes in
Dalam
various
situasi saat
areas of our
ini,
lives. In
kolaborasi
this
dan
current
kerjasama di
situation,
antara kita,
collaboration,
baik
cooperation
mahkamah
among
konstitusi
us,
atau lembaga survei di
among
negara-negara Asia
constitutional
dan
courts
Afrika,
or equivalent
selalu perlu
institutions in Asian and African
kita kembangkan
countries,
dan kita
must
tingkatkan.
always be developed
Kerjasama
and
baik pada bidang
enhanced.
yang sesuai dengan koridor kewenangan
It is
masing-masing
important that
lembaga
new cooperation
menjadi
areas which are in
kewenangan
accordance with the corridors of authority in each
administratif
institution,
penting
in
untuk
this case, in the realm of judicial
diinisiasi
power,
dan dilakukan.
must be
Oleh karena
initiated
itulah,
and implemented.
saat saya menjabat
Therefore,
sebagai Ketua Mahkamah Konstitusi
when I
Republik
serve
Indonesia dan
as
juga selaku
the
Presiden
Chief
AACC
Justice of
pada
the
tahun
Constitutional Court
2014
of the Republic of Indonesia, and
saya
also as the
berkomitmen
President of the
mempunyai
AACC from
misi
2015
untuk
to
mewujudkan
2018, I was committed and
persatuan
had a mission to
AACC dan
realize the
CCJA.
union of AACC
Saya
and
meyakini
CCJA.
kedua asosiasi
I
ini sama-sama
believe
mewakili
these two
atau mengisi
associations
semangat konferensi Asia Afrika.
both inherit
Oleh
the
karenanya,
spirit of the Asia Africa
hal-hal
Conference,
kiranya dapat
and therefore,
berkolaborasi,
there are many
supaya saling
issues
menghormati
where we can
untuk
collaborate
mencapai tujuan
within the
dan
framework of
tujuan bersama.
mutual respect in order to
Dalam
achieve common goals
2018,
and interests.
ketika
In
AACC
March of
berinisiasi
2016, when the
untuk memiliki
AACC
sekretariat,
wished to establish
saya
and to
tidak
have a
mencari
permanent
rujukan
secretariat,
mana-mana. Saya
I
segera
did not
merujuk
seek other
kepada
references. I
Aacc
immediately
untuk
referred the
belajar
CCJA
mengetahui
Permanent Secretariat
bagaimana
to
pengelolaan
study
sekretaris tetap
and determine
organisasi
how to
Mahkamah
manage
Konstitusi dalam
the Permanent
lingkungan
Secretariat of a constitutional court
regional.
organization
Saya
within a
sering
regional
bertemu
scope.
dengan sahabat saya,
I often
Bapak
met with my
Ccja
good
yang
friend,
ada di samping saya.
Mr. Laraba, who is now seated next to me. We have learned and obtained so much from the Permanent Secretariat of CCJA. We have adapted many concepts and practices along with the establishment of the Permanent Secretariat in Jakarta. After the establishment of the Permanent Secretariat of AACC, as the president of AACC, I specifically met with the president of CCJ at the time, led by Professor Mogeng, chairman of the South African Constitutional Court, among other times in Venice, Italy, in Batumi, Georgia, and also in Indonesia, in order to have serious discussions regarding cooperation plans. And this desire could be realized with the signing of the Memorandum of Understanding between AACC and CCJA, which took place in a simple ceremony in Surakarta or Solo, Indonesia. I believe today is one of the concrete manifestations of the MOU, which we implemented in order to strengthen and to also design open cooperation, both at the time and in the future. Your Excellency, the President of the AACC, the President of the CCJA, the chairs of the delegations, distinguished guests, ladies and gentlemen. One of our important issues is how the Constitutional Court, as a constitutional judicial bodies in Asia and Africa, countries have a role and contribution in maintaining and providing protection for the basic rights of citizens, enforcing human rights, and being able to build law through various rulings in order to realize prosperity for all in each country. With regard to the protection and fulfillment of basic rights and human rights, Asian and African countries have distinctive and unique characters in comparison to countries in other continents. Nations in Asia and Africa have communal values as their foundation. In this case, community interests are prioritized over interests of the individual. In Indonesia, these communal values are one of the essences of the values of Pancasila, namely upholding mutual cooperation or gotong royong. Communal values that are different from the principle of universality, including individual rights, which are upheld and have become a prominent character of Western societies. The cosmology of the Asian African nations, which have a more collective view, allows for interaction and closer relationship between peoples, but does not displace and negate one another. This clearly cannot be equated with the West, which has a more individualist lens. Edison, in his book, A Third World View on Human Rights, wrote that for us, Africans and Asians, the human image that underlies the Declaration of Human Rights is completely incomprehensible. According to this image, man is an individual who is separated from society and considered to be a carrier of complete human identity. Humans such as this, in the eyes of Africans and Asians, do not exist. For Africans and Asians, such a person, which is a person who is alone, determines his path towards his own happiness, independent of others. Sukarno called it extreme individualism, namely individualism that separates people from society altogether. This is what gave birth to liberalism, capitalism, and imperialism, which we all clearly share. Your Excellency, the President of the Aacc, the President of the CCJA, and the chairs of the delegations, distinguished guests, ladies and gentlemen. Human rights are contextual in nature. The respect, promotion, protection, and fulfillment of human rights are highly dependent on local wisdom of each country, culture, tradition, and civilization of each country. In other words, human rights must be understood in the cultural context of each country and cannot be generalized. In such a framework, it must be admitted the challenges of protecting and upholding human rights in Asian and African countries are very different from those challenges in Western countries or other developed countries. In developed countries, challenges may include contemporary issues such as pressure on journalists, blocking of internet resources, economic rivalry, same sex marriage, forms of censorship that are incompatible with media pluralism, the right to access information, the right to personal data protection, and other rights related to the threat of negative excesses of the digital industry. Meanwhile, in Asian and African countries, the factual enforcement of human rights is still related to the effects and instability or internal state political conflicts, violence, intolerance, freedom of expression, discriminatory treatment of minorities and vulnerable groups, rights of persons with disabilities, access to health, migrant workers, and the like. This fact necessitates an approach to the protection and enforcement of human rights with a different focus, approach, and values between individualist Western countries and communalist Asian and African countries. Therefore, the AACC and CCJA Joint Conference Forum is expected to be a new avenue for collaborative cooperation between constitutional justice bodies, especially to take part in potential solutions in order to overcome existing challenges in the current condition. Your Excellency, the President of the AACC, the President of CCJA, the chairs of the delegations, distinguished guests, ladies and gentlemen, the Constitutional Court of the Republic of Indonesia, as part of AACC, which has taken part in the 1955 Asian African Conference, stands ready to continue the togetherness and solidarity of Asian and African countries, to increase closer cooperation in various fields, especially in upholding the principles of rule of law, constitutionalism, democracy, as well as the protection and fulfillment of human rights in an effort to realize the common welfare of all its people in Asia and Africa. Finally, I also support the continuation of the joint conference in the future, including the possibility and opportunity to establish a permanent secretariat with the Asian African Constitutional Courts. The goal is to strengthen cooperation among us so that we are strong together, we recover together in order to guard the progress of civilization and the dignity of Asian and African nations based on the principles of justice and eternal peace. That is all for me. I thank you. Religious greetings. Peace be upon us all. May God bless our joint endeavors. Thank you.
شكرا لسعادة المستشار عارف هدايات على هذه المداخلة الهامة والقيمة والتي أعاد بنا.
Thank you so much for the extraordinary remarks by Mr. Arif Hidayat, and he helped us to reminisce on historic events such as the Bandung Conference and reasserted that the challenges that are faced by Asian and African nations are different. And if organizations from the two regions cooperate, then it would help us address those challenges. Now, we will shift to the second speaker, His Excellency, President of the Constitutional Court of Ethiopia. He could not be here but insisted to contribute. Before I move to, excuse me, the President of the Constitutional Council of the Republic of Ethiopia will intervene virtually now. I will invite the second speaker from the Constitutional Court of Algeria. He's a lecturer, also chair of the Commission on Sustainable Development. He's a member of the University Senate and has written extensively on the theme of constitutionalism. He's also an active member to examine dissertations and theses in the university, and he has been a part of the Constitutional Court of Algeria. And after the last amendment of the Constitution, the mandated composition of the Constitutional Court of 50% from universities, and that is why he's part of the Constitutional Court. Go ahead.
المعنونة بضمان وكفالة حقوق الحريات الأساسية في الجزائر.
My contribution today will be about how the Constitution can improve the situation of human rights. However, I have to express my deep thanks to one of the cities in Algeria, one of the cities in Indonesia, which is Bandung, where our forefathers also supported the Algerian Revolution, and that is why allow me to pay respects to the city of Bandung and to the nation of Indonesia that has allowed us to obtain our independence in 1960, and as was declared in the UN Charter that every nation has the right to their own independence. The Algerian delegation was also present in that conference, and we have been participating in building up the non-aligned movement.
وباتت بطبيعة الحال عضو بارز.
The Algerian delegation was also a central and prominent member of the non-aligned movement. before we talk about individual rights, we have to talk about collective rights. It is impossible for any individual to enjoy their rights under oppression, and this is something that underlies, that is the underpinnings of individual rights. And even though these rights are considered to be international, even though I choose to call them to be more human than international, there are unique characteristics of every nation and every countries, and the application or the implementation of those rights in Algeria cannot be the same as the application of those rights in Europe, for example. So these are some considerations in the implementation of human rights, including the distinction that we have between individual rights and collective rights. Algeria has gone through various phases in that regard, and almost all African countries have gone through those phases where initially they were dependent on the colonizing countries, and that's why there was a need to establish a constitution that was different. Algeria has adopted a constitution that is called a one that is directed by this project, which is making people independent. And this emphasizes economic and social rights to improve themselves economically, to find work, to obtain education, and also to be provided with health. And then in 1976, it became what's called a programmatic constitution. In the 1970s, we can see
بين قوسين لأن الإنسان
more attention given to individuals, but still emphasizing efforts to prevent hunger and poverty before trying to protect civil and political rights. Algeria took a gradual route in addressing human rights. In 1989, there was a constitution that was not a program constitution, but one that is more the constitution of law. We became open to pluralism and politics, and also open to democracy. But one still considers our unique tradition and culture. In the 1989 Constitution, which was amended after the major political crises in Algeria, which is the dark 10 years from 1990 to 2000, when there was a coup that halted democratic efforts. But the 1989 Constitution, which was open to political pluralism, it did not use the term political parties, but associations instead. And in a very short time, 60 political parties sprang up and All of them were led by former fighters, freedom fighters for the independence of Algeria. Those political parties many of them also violated the constitution when there were political parties that went against the principle of territorial integrity. That is why in the next amendment, it was prohibited to establish a political party based on groups or ethnicity or religion or regions. The crisis that occurred in 1990 was also related to the existence of those political parties. Unfortunately, the casualties were massive in the hundreds of thousands. Further amendment rectified that error. For example, in Article 41, that limited the freedom of establishing political parties, also changing the name from association to parties. However, there were some limitations or delineations to the political parties, not allowing them to be established based on nationality or ethnicity or religion. There is one article that focuses on the human rights. This was in 2016 and 2020. A separate chapter was set for fundamental rights and freedoms. In every amendment continues to expand on these freedoms. And if we compare the 2016 constitutional amendment with the 2020 constitutional amendment, we see there's an additional 2 more articles. That also expanded the authority, the power of the Constitutional Court, and to clarify it. I also would like to spend time on the issue of naming human rights, and I have mentioned that this is different from one nation to another. One thing that is considered important by one country and one nation might not be considered the same by another country and another nation. We have social, political, and civil rights, and all of them have been clustered, and they are asserted in the chapter on human rights in the Constitution, not only in terms of politics, but also in socio and economic terms, and even cultural rights as well. And that is why when we talk about human rights in Algeria, we not only talk about political rights, but all rights that pertain to the individual as a human, so that they can live a dignified life with high status and stature. I also would like to say that in realizing human rights, Algeria has taken the gradual route according to the phases that have been studied well to avoid us making the same mistake as we did in the 1990s. We have 2 more minutes, 2 more minutes. We have shifted from a constitutional council or assembly to a constitutional court. This is not merely a name change, but this was due to the most recent movement or revolution in Algeria. That shift from the Constitutional Assembly to a constitutional court was one of the main programs by the president at the time. The new powers of the Constitutional Court included conflict resolution between state institutions and agencies, and the Constitutional Court became the main guarantor of human rights. In the previous body, they were the constitutional protector, but now we are the constitutional enforcer. I'd like to add more time to talk about the judicial review, which is to review laws in terms of their constitutionalities. And we have given the rights to citizens to approach any
العام
court to review and revise laws, and those courts will refer those cases to the Constitutional Court. So this is a two-step process whereby a case can be arranged. The Constitutional Court, starting November of 2021, and if we compare the powers to the previous body, there were 35 decisions in 30 years. Many of those decisions were about general elections. However, the Constitutional Court, starting November 2021 until now, we have issued 41 decisions. 6 on general elections, and the rest of the constitutional review of legislation, and 2 decisions on our internal system of the Constitutional Court. Last thing that I wanted to highlight is the Constitutional Court is something of a new experience for Algeria, and the Algerian Constitutional Court is quite unique in some terms because it has 12 members. Half of them are university professors. There are also representatives from the judiciary, and all of them, none of them can have any political affiliation. They also, the Constitutional Court also cannot have any representatives from the legislature. This is to maintain independence. I hope this. Thank you, Mr. Chair. Hopefully this is not have been so troublesome for you. the Constitutional Accord of Algeria the Constitution of Algeria has contained principles that has existed ever since before the independence and after the independence. And the newest constitution has brought Algeria into a new era, one that is free of oppression and imperialism. I thank Professor Abdul Wahab Harif, a member of the Constitutional Court of Algeria. The next speaker will be His Excellency Mr. Zuktu Arslan, the President of the Constitutional Court of Turkey. And he graduated from the Ankara University in 1980 and then continued his studies in Leicester University in the UK. And in 2007, he joined the Constitutional Court, and he also worked and has contributed to the Alliance of Journalists and has explored constitutional theories and has taught in several universities and have written a few books, 3 books on the law and on constitution in 3 volumes, as well the history of the Constitutional Court and a comparative study between the constitutional law of the US and Turkey. Also
2012 من بين 3 مترشحين اقترحهم مجلس التعليم العالي تم انتخابه رئيس للمحكمة الدستورية من قبل الجلسة العامة للمحكمة في 10 فبراير 2015.
And as he was elected as the President of the Constitutional Court in 2015 and was re-elected. You have 10 minutes.
Thank you, Mr. Chairman. My dear friend, Dr. Ömer Usman, the President of the Constitutional Court of Indonesia, distinguished presidents of the Aacc and CCJA, distinguished presidents of the Constitutional Courts of Asian and African countries, distinguished members, guests, and ladies and gentlemen. It's a great pleasure for me to be here at the joint conference of Aacc and CCJA. I hope and wish that conference will be very successful and very stimulating. And I would like to congratulate the Constitutional Court of Indonesia, especially its president and his colleagues, for organizing such a wonderful conference and for their warm hospitality. I would also like to express my deep condolences to the Indonesian people for the soccer accident happened last weekend. Ladies and gentlemen, I was required to speak on the principle of equality as prescribed in the Bandung Declaration of 1955. As you all know, that this declaration emphasizes the recognition of the equality of all races and of the equality of all nations, large and small. There is no doubt that the principle of equality is a sine qua non condition for establishing a just political order at both national and international level. For sure, the principle of equality as prescribed by the Bandung Declaration refers to the equal status of every race and every nation in the world. In other words, equality must prevail in international political order. Therefore, the unequal structure of the United Nations system, which granted, as we all know, the 5 nations the right to veto, must be re-evaluated in the light of the Bandung Declaration. The ultimate success in establishing an efficient and just international order depends largely on unanimous acceptance of the idea that some of the nations are not more equal than others. All nations and races are equal, and some of them are not equal than others. Distinguished participants, the principle of equality is also one of the basic constitutional principles at national level. Almost all constitutions enshrine this principle, even though they formulate it in different ways. Indeed, the principle of equality lies at the heart of modern idea of universal human rights. Equality is a fundamental human right which affects the scope and exercise of almost all other rights. That is why Ronald Dworkin regarded so-called the right to equal concern and respect as the source of all other rights and liberties of individuals. Now, I would like to say a few words about the protection of this significant principle, this significant right to equality in constitutional order of Turkey. Article 10 of the Turkish Constitution is the main provision drafted to protect and promote the right to equality and also the principle of non-discrimination. This article stipulates that everyone is equal before the law without distinction as to language, race, color, sex, political opinion, philosophical belief, religion, and sect, or any such grounds. And the last paragraph of this article clearly imposes a positive and negative obligation on the public authorities. Accordingly, the legislative, executive, and judicial organs are required to act in line with the principle of equality. I must note that this article is not formulated in a way that cites the prohibition of discrimination in its wording. However, as the case in many jurisdictions of democratic countries, the principle of equality embodies the prohibition of discrimination as a standard norm. Therefore, the Constitutional Court of Turkey has interpreted this article at the same time as a constitutional provision prohibiting discrimination on the basis that I have just mentioned above. The Turkish Constitutional Court has adopted a 3-level test in interpreting Article 10 of the Constitution and determining whether the principle of equality has been breached. First of all, the court decides whether there is a difference in treatment among the persons whose legal status are the same or similar. First, we check the existence of the difference in treatment between individuals. If there is a different treatment, the next question is whether it has an objective and reasonable basis. And finally, if the difference has such legitimate ground, the court applies the test of proportionality. In other words, it seeks for the balance between the restriction and legitimate aim of this different treatment. The court has developed and applied this test in the fields of constitutionality review as well as individual application. Let me give you a few examples in order to reveal the court's case law concerning the principle of equality and non-discrimination. In a constitutionality review case last year, the court dismissed the request for annulment of the provisions allowing for an increase in penalties for offenses committed against healthcare professionals. The court held that the principle of equality before law applies to the comparable cases, and it is obvious that healthcare professionals and the other public officials are in a comparably similar situation. The Constitutional Court found an objective and reasonable ground by referring to the diligent nature of the health service and the increasing number of the crimes against healthcare officials. And according to the court, the increase of the punishment by 50% was proportionate to the aim of protecting healthcare staff against physical and mental attacks or assaults of others. In 2014, the court examined a case of individual application which concerned a female lawyer's expulsion from a courtroom for wearing a headscarf. As probably you know, that headscarf issue has been the subject of heated debate in Turkey for a long time. The applicant claimed that she was discriminated against on account of her religious beliefs. The court held that no objective and reasonable ground was presented for preventing the applicant from taking part at the courtroom by wearing a headscarf. Therefore, since the applicant was put in a disadvantageous situation compared to those female lawyers not wearing a headscarf, the prohibition of discrimination guaranteed by Article 10 of the Constitution was violated. The Constitutional Court has also dealt with gender-based discrimination issues. In all these cases, following the footsteps of the European Court of Human Rights, the Constitutional Court has stated that discrimination based on gender constitutes an explicit contradiction to the principle of equality. To give a vivid example, the court has emphasized the importance of gender equality in the context of the change of the surname of the child under custody after divorce. The court held that the principle of equality requires man and woman to have equal rights before law, and any discrimination on the basis of gender would be contrary to the principle. In conclusion, the principle of equality, alongside the concept of human dignity, is the core value behind the idea of universal human rights. It is a right in itself and a basic principle for the exercise of the other human rights and freedoms. The primary duty of the constitutional courts and equivalent bodies is to protect the right to equality by interpreting and applying it to the concrete cases arising from various examples of discrimination. We shall not forget that the precondition of protecting and promoting the principle of equality is to respect and recognize the ontological status of the other, who is different from us. In this regard, we should learn from Mevlana Jalaluddin Rumi, who built a philosophy based on the equal dignity of human beings. Rumi said 8 centuries ago that there is no servant or slave. All people are brothers and sisters. I think this everlasting formulation of the equality and human dignity is the starting point for the protection and promotion of the principle of equality at national and international political level. Thank you very much for your attention.
شكرا لسعادة المستشار زهوتو أرسلان رئيس المحكمة الدستورية في تركيا على هذه المداخلة القيمة والتي طاف بنا فيها حول الحقوق والحريات وركز فيها خاصة على مبدأ المساواة كمبدأ لا يمكن التمييز فيه عند تطبيقه، كما أشار إلى أن المحكمة الدستورية في تركيا أصدرت الكثير من القرارات ومن الاجتهاد المتعلق بالحريات والحقوق، وهي تعرف بطبيعة الحال إنتاج غزير في الفترة الأخيرة من القرارات الهامة التي تمس مباشرة الحقوق والحريات كمبادئ أساسية لا يمكن التخلي عنها. شكرا مرة أخرى معالي الرئيس. قبل أن أحيل الكلمة إلى آخر متدخلة وهي قاضي القضاة بجمهورية الفيدرالية لإثيوبيا ورئيسة المجلس الدستوري للتحقيق في إثيوبيا، هكذا يسمى The Constitutional Council of Inquiry in Ethiopia، مجلس الدستوري للتحقيق، والتي كما قلت سابقا تعذر عليها الحضور معنا لكنها أصرت على المشاركة ومقاسمتها مقاسمة أفكارها معنا. إذن قبل أن أحيل الكلمة للمتدخلة أشير إلى بعض المحطات من مسارها المهني، فهي أول امرأة تتولى القضاء كرئيسة قضاة في إثيوبيا، وتحت قيادتها شرعت المحكمة العليا الاتحادية في برنامج إصلاحي قضائي شامل، كما قادت تطوير برنامج مشترك لمؤسسات قطاع العدل والذي سيتم تنفيذه خلال رئاستها القضائية، وتتطلع إلى استعادة ثقة الجمهور في القضاء وضمان استقلال القضاء في إثيوبيا. قبل تعيينها كرئيسة للقضاة كانت السيدة ميازا تعمل في مجال تعزيز حقوق الإنسان والدعوة لوقف العنف ضد المرأة وضمان وصول المرأة إلى التمويل البنكي.
So on human rights, and so that women can obtain finances for their small businesses. He also worked as the executive director at a women's organization and has promoted many different women's rights to obtain financing and contributed in the setting up of the first bank that caters to women and prioritizes women to obtain access to finances for their entrepreneurship. For her very dedicated achievements, she has been given many different awards, such as by the US in 1998, and His Excellency will also intervene via video recording.
Honorable Chief Justice Anwar Usman, Chief Justice of Constitutional Court of Indonesia, Honorable Chief Justice of African and Asian Constitutional Courts, distinguished guests, ladies and gentlemen, I am highly honored to speak with Honorable Chief Justices and the Justices who are gathered from Africa and Asia. The Global Conference is truly a platform for Chief Justices and the Justices to share their experiences in adjudicating constitutional disputes and to discuss the function and roles of the courts in disposing landmark decisions that could affect the life of a given community or country. This conference, I'm sure, will serve this purpose fully. The relationship between Asia and Africa dates back several decades. Ethiopia has a long-standing relationship with many Asian countries due to its long history in war and peace. in trade and diplomacy. The position of Ethiopia as an independent and thriving country has helped to advocate for decolonization of Africa and other countries in various arenas, including in the League of Nations, and later its successor, the United Nations. The Bandung Conference, which was held on April 24, 1955, was attended by 24 countries from Africa, Asia, and the Middle East. However, the countries that were present at the conference from Africa were only Ethiopia, Egypt, and Sudan, since most of the African countries were under colonial rule. The conference was truly consequential because the themes discussed in the conference and the ultimate declaration has contributed to the decolonization of Africa and the realization of economic, cultural, and political independence of these countries. The Bandung Conference was held in the eve of the Cold War, which lasted for decades to come, and the conference called for non-aligned movement and neutrality. Areas of cooperation between Africa and Asia were identified and ranged from economic and cultural cooperation to human rights and self-determination. The theme of this conference being on the role of constitutional jurisdiction for the protection of human rights and the maintenance of peace resonates with the goal of achieving the promises of the Bandung Conference. The fact that most African and Asian countries have introduced the concept of constitutional adjudication of human rights after the Bandung Conference is also an important milestone in attaining the pledge made under the declaration. After more than 65 years, the adoption of the Bandung Declaration, the situation of human rights has improved significantly in both Africa and Asia. The conference, which will be held in the historic country of Indonesia, where the Bandung Declaration was adopted, is helpful to renew our promises for human rights and peace building. Ladies and gentlemen, protection and promotion of human rights is predicated on peace and democracy. Peace and democracy are key factors to meet the needs of citizens, prevent grievances that arise, and resolve disagreements without the use of violence within the framework of the rule of law. As such, states that respects and upholds human rights and the rule of law to prevent and address grievance is more likely to witness peace and stability. Honorables, formal laws, including the Constitution, guarantee basic human rights and freedoms. Informal social and cultural norms that relate to behaviors of citizens serve as proxies for the level of tolerance between different ethnic, linguistic, religious, and socioeconomic groups within a country. In functional democracies, individuals are less likely to resort to violence because they know that their rights are guaranteed by robust, inclusive, predictable, and independent institutions. Grievances will be handled through relatively peaceful and constitutional mechanisms. States are obliged to respect, protect, and fulfill the fundamental human rights enshrined in their constitutions and international instruments to which they are a party. As such, citizens need to ensure access to effective mechanisms and institutions to address concerns and prevent or end cycles of discrimination, marginalization, and violence. In addition to the judicial branch of the government, including constitutional courts, the existence of solid, independent institutions that address social issues are important for mitigating the likelihood of violence. At national levels, various institutions have been created to address respect for human rights, including human rights commissions, Office of Ombudsman, and other non-governmental organizations that are working to ensure the respect and the promotion of human rights. Honorable judges, in Africa, the immense task of interpreting constitution is vested either in constitutional courts, fully dedicated to constitutional interpretation, or the task is mandated to the highest judicial echelons. Such arrangements reflect the global trend. Perhaps there are few jurisdictions that follow slightly different arrangements. Ethiopia is one such jurisdiction. We follow a different modality of constitutional interpretation. Under our constitutional arrangement, a council called Council of Constitutional Inquiry is mandated to receive complaints pertaining to constitutionalism. The body is constituted of 11 members and is chaired by the President of the Federal Supreme Court. Members of the council are drawn from the upper house of the parliament and prominent members of the legal community. The mandate of the Constitutional Council is limited to issuing advisory opinion. The ultimate responsibility to adopt the recommendation is vested with the upper house of the parliament. Such arrangement raises interesting debates, but it is not quite exceptional to include political representatives in constitutional adjudicative bodies. In 2021, the Constitutional Inquiry Council made a landmark recommendation on the extension of government authority, since it was not possible to conduct the election in accordance with the constitutionally provided timeframe for general elections due to the COVID-19 pandemic. The Constitution has stipulated that the term limit for a federal government is 5 years, and the year 2021 was the 5th year of the elected government. The matter referred to the Constitutional Council was whether it was possible to extend the term limit of the government given the condition of COVID-19 and conduct an election within a reasonable future time. The case was referred to the Council by the House of People's Representatives for a constitutional interpretation. The Council well understood the gravity of the case and made special plans to make the deliberation. We invited professionals to submit amicus curiae on the possibility of extending the term limit of the government in some exceptional situations. We made sure that the deliberation was televised to the general public, since the issue is a matter of great public interest. Hearings of relevant institutions such as the Ethiopian Electoral Board and the Ministry of Health were also conducted. Prominent constitutional lawyers also participated in the hearing. Following the conclusion of deliberations, the Council has issued its recommendation to extend the mandate of the government for 1 year.
وهذه التوصيات قد وضعت من خلال تفسيرات للمبادئ المختلفة، وقد قامت المحكمة بالتوقيع على هذه التوصيات.
Ladies and gentlemen, honorables, I have raised this example to demonstrate the important role of constitutional jurisdictions to maintain peace and democracy. Constitutional adjudication bodies have tremendous responsibility in developing and nurturing constitutionalism, ensuring that the rights of individuals, communities, and the functionality of the state is affirmed and respected. Conferences such as this provide great opportunity to share experience and learn from one another. It is also important that constitutional adjudicative bodies should communicate their work to the public by using various platforms. This will ensure transparency and legitimacy of our work. Communication is also useful to educate the public about the Constitution and how and when the public should exercise their constitutional rights. Honorables, our world is facing multiple challenges ranging from economic crisis, climate change, conflict, and the negative impacts of digital revolution and a global pandemic such as COVID-19. At our respective jurisdictions, cases related to such critical and existential matters are submitted to us. Hence, we do have an immense responsibility to shape the future of our societies by using the rule of law and administration of justice as a vehicle. The role of the rule of law for peace, inclusive and sustainable development is provided under Sustainable Development Goal 16. The goal aims to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. I wish I was able to join this important meeting in person. I wish you a fruitful deliberation and thank you for your attention.
Thank you very much for Her Excellency for her intervention, which has shared with us her thoughts in this African Asian conference, which she stressed on respecting the rule of law and equality and the role of the Constitutional Court in Ethiopia and especially in the African continent. Once again, I would like to express my gratitude to Her Excellency for participating in this conference. And now I would like to open a session for questions and answers. This session will last around 20 minutes and I will give the speakers opportunities to respond to questions from the participants. Please state your name and your institution before giving your questions. Thank you.
هل من سائل؟
Are there any questions?
Monsieur le Président, à vous la parole, s'il vous plaît, merci.
Je vous remercie,
I would like to thank you, dear friends, Musa Rabba, for being moderator of this first session concerning the association of these two continents. I don't have any questions because I think that the questions, what the speakers had said is already clear enough. I would simply like to speak, first of all, to thank the President of the Constitutional Court of Indonesia, the Indonesians and the government of Indonesia to have allowed this conference to take place in this beautiful country, which is like a dream for many people. Many people dream of coming to visit here. And I am one of those people who really wanted to visit Indonesia. So for this, I would like to thank you. I would like to thank also all the organizers who, from the minute we arrived here, have accompanied us during our stay. which has been very peaceful, and everything was very easy. It was easy for us to adapt in this, and we are here coming from a very dry country. It's also nice for me to see all this rain. Thank you, Mr. Laraba, because we know each other, but I am just one president of the Constitutional Court of Djibouti. I would also like to say a word about the presentations about the cooperation, Africa-Asia cooperation. The Bandung conference that you have spoken about which was underlined first of all by the president of the Venice Commission, and which was repeated by other speakers. Unless I'm mistaken, this conference was was an essential conference for the people's rights. One element of this declaration was the president of the Supreme Court of Ethiopia had said so, is that the peoples of Africa and Asia that were under colonial rule, they obtained independence. This is the first protection of fundamental rights. It goes through a government that can ensure a minimum of fundamental rights in a national context. This results in, unless I'm mistaken, we come to the elaboration of what we call the second generation fundamental rights, which are collective rights before we apply individual rights. The Pact of the United Nations on Civil Rights, or the impact on social and cultural rights. Sir, could you please have a question, or can you resume, because other people would like to speak as well? Just to underline, and a coordination of the Africa-Asia efforts will help evolve, help us to face the different challenges. The idea was launched to create a joint secretariat of the two associations. So there you have it, Mr. President, my dear friend, the few words that I wanted to say. Thank you. Thank you, Mr. the President of the Constitutional Court of Djibouti, and for his support to the setting up of a secretariat, a joint secretariat between the CCJA and the AACC. Thank you, Mr. President. Now I would like to invite the President of the Constitutional Court of Algeria.
Thank you very much, Mr. Araba.
Thank you.
First of all, I would like to thank the organizing committee and also the all the participants in this conference. I would like to add several points to what Mr. Kharif has already stated, where Mr. Kharif has talked about the crisis of Al-Ashriya in Algeria, which was caused by terrorism. Algeria, as you know, has always warned against the danger of terrorism, especially after 9/11. Everyone has reinforced our approach And in 2002, the George W. Bush, the President of the United States, who affirmed the Algerian approach. And secondly, I would like to note that Algeria, concerning the Constitutional Court, has taken a gigantic step. And Mr. Abdelmajid Tebboune has also affirmed what my colleague here has also talked about, that we need to take things in gradually. We need to take into consideration every step of the way, because that is that way we can study every aspect pertaining any change that can be constructed in the constitutional law. And our current stage is a very significant and critical stage. However, I believe in being gradual, and I believe that would result in a better outcome for everyone. Thank you. Thank you very much for Mr. Misbah, a member of the Algerian Constitutional Court, and Omar Belhaj is the head of the Algerian Constitutional Court. Thank you.
Est-ce qu'il y a quelqu'un qui veut poser une question?
Is there someone that would like to ask? Are there any questions?
I would like to know that the head of the Constitutional Court of Ethiopia is available virtually with us, and if anyone here would like to address any questions to her, she will be available to answer.
Et aussi qui peut répondre à votre question ou à vos questions si vous avez des questions.
Which has been declared in Indonesia. Ethiopia now is the capital of the political capital of Africa. So Bandung and Addis Ababa both are big symbols in the political movement for Asia and Africa.
Bandung ensuite qui a joué un rôle important. Si pour l'Indonésie, vous avez 5 principes dans votre constitution. Pour ces 5 piliers ou 5 principes qui viennent directement de début de votre constitution qui a été inspiré par l'indépendance de l'Indonésie. Est-ce que vous pouvez nous expliquer quelle est donc l'origine de ces principes donc, dans le mouvement de l'indépendance? Est-ce qu'il y a des impacts sur la constitution aujourd'hui? Merci.
There are fundamental values and there's state ideologies which was utilized as the foundation for how the society lives, our statehood and nationhood, these five ideologies, which was initially called the state fundamental norms, were enshrined in the opening of the 1945 Constitution of Indonesia when our founding fathers formulated the Indonesian Constitution in 1945. These five basic principles or state ideology was not taken or imported from external theories, but rather these were taken from values which has long been understood and implemented in our society in Indonesia prior to independence. So by Sukarno on the on the 1st of June in 1945, this was in his speech when the founding father formulated the Constitution. These values are universal in nature. For example, the first ideology is called the unitary God. From its inception, the people who live in our archipelago have always been religious in their lives, in addition to acknowledging living together as part of humanity. They recognize that there are divine hands beyond the understanding of human beings. And this is then called in Bahasa Indonesia as the Almighty God or the Unitary God. All the ethnicities in Indonesia may have different terms for this. And in 1928, we raised a lingua franca called Bahasa Indonesia, and this religious term became the unitary God. And the collective value, the value of tolerance, the deliberation to reach consensus, these are practices from the various ethnicities in Indonesia. Therefore, this philosophy was raised as a basis in our nationhood, our statehood, and our society in Indonesia. And this has been practiced in the 70 years of our independence. Although in its implementation, we have seen the rise and fall. There has been some lack of tolerance, but then these bonds remain the foundation. And to date, the people of Indonesia utilizes these foundational philosophies of our country. This does not change during the era of Reformation in 1978. The values enshrined in the fourth paragraph of the opening of the Constitution remain upheld and will be upheld as long as the Republic of Indonesia stands. And in perpetuity, That is my explanation, and there is actually so much more we can discuss further at an implementation, from an implementation perspective. Thank you.
Thank you very much for that comprehensive answer. Are there any other questions?
Représentant de la Cour constitutionnelle du Royaume du
Okay, for Morocco.
First of all, I would like to thank Indonesia and the head of the Constitutional Court for hosting this event, and also the moderator of this session. AACC and CCGA does represent the spirit of Bandung, and all the interventions that we have heard have stressed on the spirit of Bandung and the unity of the of Asia and Africa. We face the same challenges. We have the same worries, and we are working on somehow similar levels judicially. And I believe that the cooperation between the two continents will definitely fasten the developments in judicial law. And I would like to quote the speaker from the Constitutional Court of Indonesia when he talked about the laws of the private citizen and how it can be in line with the rights, the civil rights and the right of the community, because this is a very important issue that we in Morocco do face, and I hope the speaker of the Indonesian Constitutional Court would elaborate on this issue. And in Africa and in Asia, I believe that it's time to coordinate our efforts in establishing a secretariat in order to affirm our unity and our cooperation. Thank you very much. And once again, I would like to thank the chairman of this session. Thank you very much for your question.
Terima kasih dari Mbak Urko.
Thank you.
Sebelumnya, ini ada apa yang disampaikan oleh
As mentioned by Professor Aslan, the president of the Constitutional Court of Turkey, can the organizer correct this? Because there is some trouble with the English interpretation. Please make sure that we can have a proper discussion. Please ensure there is interpretation. So to return to our discussion, indeed, there is a common desire. When I held the position of the president of the AACC, together with the president of, with Professor Aslan as the president of the Constitutional Court of Turkey and the president of the Constitutional Court of South Korea, Professor Park Han-jo, that there will be the establishment of a permanent secretariat for AACC. I conducted a comparative study to CCJA and Algiers, and I happened to meet with Mr. Larapa to discuss how Africa, who actually had a permanent secretariat already, and the outcome of these discussions. So through these discussions, I had a bilateral meeting with Mr. Arslan and Mr. Park Han-joel in Seoul, and we arrived at a modification in our establishment of the permanent secretariat. The permanent secretariat was established in Jakarta, and the Turkey Constitutional Court was given the mandate to convene a center for education and training for justices and all the components who provide support for the judges in implementing their duties. So was given the mandate, the Constitutional Court of Korea was given the mandate to become the Center for Research and Development in the development of constitutional courts in Asia, including research and development related to the development of the duties and functions of constitutional courts in Asia. This was a refinement or modification from what we had learned from the permanent secretariat of CCJA in Algeria. There we had a common idea. We had met in Bandung in 1955. Asia Africa has extraordinary similarities. From this perspective, the idea was born to establish a cooperation, which was also guided and directed to establish a permanent secretariat. This depends on the member states, whether part of CCJA or AACC. This was the beginning of this conference that we are holding today. This was the beginning of the implementation of the MOU between CCJA, which at the time the presidency was held by the president of the Constitutional Court of South Africa, Professor Mogo Mogo, together with myself in the city of Solo. This was the embryo. This MOU brought about the first conference, which is today. So we have the CCGA and AACC conference. Will we then follow up by establishing a permanent secretariat? With the permission of the president of the Constitutional Court of Indonesia, I have been given the mandate to state that if we can come to an agreement, Indonesia also is willing to be the permanent secretariat of this joint association between CCJA and AACC. However, this depends on all the members who are part of these two constitutional court associations of Asia and Africa. So this forum, we continue the development of these forums. If we cannot come to a consensus at this point, let us together periodically continue convening joint conferences in order to develop democratic states or those based on constitutions, which does not undermine the function of each constitutional bodies in their respective countries. Our organization, together we can develop that. So rule of law is not merely countries based on rule of law, but rather being able to provide benefit, prosperity, because essentially democratic countries, countries that are based on the constitutions, are the objective of these countries are to realize prosperity for its people. We often speak about countries based on rule of law, democratic countries, but actually the goal, the direction is to fulfill the basic needs, prosperity of all its citizens, for all the residents living in Asia and in Africa. This is the key issue that many of our people have not yet been able to meet decent livelihoods viewed from any aspect. So let us together work to strengthen the judiciary bodies so that we can encourage all our countries to bring about peace, order, as part of our endeavor to realize prosperity for our citizens. I think that is my remarks, and I believe we can discuss this further as part of our endeavors to do so. Thank you.
Mr. President from the Constitutional Court of Turkey, please.
رئيس المحكمة الدستورية التركية. فليتفضل مشكورا.
Brother has already said, Professor Arif Hidayat. I agree with him that we should continue discussing common subjects of the constitutional courts and councils or Supreme Courts, because at the end of the day, we are all doing the same job, that is to protect rights and liberties of our citizens, as well as upholding the principle of rule of law and democracy. So I think this event of joint conference is a historic moment for all of us, and this is the first joint conference we are exercising, realizing. I was also in Solo when the MOU was signed between the AACC and CCJA, and it was also a historical moment. But now we are realizing this first project of joint conference, and I hope we will continue to do so. Perhaps we should regularly meet as the members of the AACC and CCJA to discuss certain thematic issues concerning constitutional justice. As my dear friend Arif Hidayat already mentioned, Turkish Constitutional Court is part of the permanent secretariat of the AACC. We are currently holding the responsibility to organize summer school programs for 10 years. Actually, 10 days ago, we organized the 10th international summer school program with the participation of over 30 countries from all over the world, in fact. And many participants were coming from African nations, African countries. We had participants also from Balkan states and also Asian countries. And we had wonderful event to discuss the topic of interpretation of constitutions in order to protect rights and liberties. We exchanged views and experiences in our respective countries, and we had actually very fruitful and stimulating debates during the summer school program. We should, in brief, continue to organize such meetings in order to share our experiences in the field of constitutional justice. Thank you very much.
Thank you so much, Mr. President. أريد فقط أن
I would like to congratulate the head of the Constitutional Court of Turkey, because Turkey is in Asia, but it is also a supervisor in the CCGA, and Mr. Arslan is a very strong participant for all, for any forum concerning CCGJ, and the Turkish Constitutional Court is always present, whether these forums are concerning conferences, academic research, or cooperation. And what we are seeing right now cannot be done without the contribution of Turkey, of the Constitutional Court of Turkey, and Professor Hidayat at that time with His Excellency Mukbin, who is preceded now by Muzung, who is the head of the Constitutional Court in South Africa, and who also contributed in the contributions between the cooperation between Asian and African Constitutional Courts, and Mr. Kokikyu, who also contributed in in 2011 and the conference for constitution jurisdictions in the continent of Africa. And I would like to thank all parties that have contributed in making this dream a reality. And Mr. Hidayat is very happy for seeing the seeds of his work come into fruition. And today we are tasting the fruits of the founding fathers of this movement. And as Mr. Asalan has stated, this is a turning point in the constitution of justice in Asia and Africa, because for the first time in history, those two continents are uniting in promoting peace and equality in order to be at the same level with other countries who are on the forefront of promoting justice through constitutional laws. Lastly, I would like to thank all the participants, and I would like to once again congratulate the Constitutional Court of Indonesia for organizing this this event. I would like to thank all the speakers and all the participants. I hope to meet you again in the next sessions. Thank you very much.
Right, thank you very much once again for Mr. Musa Laraba for conducting our first discussion, and also thank you for all speakers. Right, ladies and gentlemen, excellencies, and distinguished guests and delegates. Let us move to our second agenda, to the second session of our discussion that will be moderated by Mr. Niao Diouf, representative from the CCJA, and Mr. Purnomo Ahmad Chandra, Director of Law and Political and Security Treaties of Indonesian Ministry of Foreign Affairs. To the gentlemen.
Good morning. Honorable judges, participants, delegates, ladies and gentlemen. So I would like to, I was asked by the Constitutional Court of Indonesia to moderate this, actually the final, almost the final session of this meeting. So I'm very proud to be accompanied by Honorable Ccja Diouf from Senegal. Before I begin the session, I would like to inform a bit about the process of drafting this joint declaration, joint statement. So before this conference begin, there was a consultation between the Aacc Secretariat and CCGA related to this drafting for quite some times. And if you look, I hope everyone already got this 2 pages paper in their table. If you haven't got one, you can ask the usher in the row to give you the paper. So after the consultations, both of the secretariat already agreed in most of the paragraph, but there are at least there are 2 paragraphs which is just been drafted today, because we have to wait until the team has been discussed. So I beg your indulgence and I would like to urge delegations, if they can, if there's not too much of a problem for you, then we can move along while I will read this statement in a dictation mode. So in each paragraph after I read, if there's no comment or additional wording, then we move forward until the end of this statement. Would that be agreed for everyone? Okay. I don't see any hands, so let's start. I will read this joint statement, the draft, by dictations mode. And I would also remind delegates that I have only very small time before lunch to finish this statement, and I hope the delegates could agree with the time as well. So I will start with the title, the joint statement, the first joint conference of the Association of Asian Constitutional Courts and Equivalent Constitution, AACC, and the Conference of Constitutional Jurisdiction of Africa, CCGA, Bali, Indonesia, October 4th, 2022. Okay? Okay. Okay, now we begin with the first paragraph. We, 39 jurisdictions of the Association of Asian Constitutional Courts and Equivalent Constitutions, AACC, and the Conference of Constitutional Jurisdiction of Africa, CCGA, gathered at the first AACC-CCGA joint conference under the theme of promoting Asian-African cooperation for the protection of people's fundamental rights on 4 October 2022 in Nusa Dua, Bali, Indonesia. I think this is a very simple paragraph. I think we can agree in this. So the second paragraph.
Excuse me?
Yes, please.
From Indonesia here.
Oh, okay.
In the address of the joint statement Bali, Indonesia, October 4th, 2022, why we not use Bali also in the first paragraph? In Nusa Dua, Bali, also in Bali, Indonesia.
Okay.
Yeah,
So
thank you.
the suggestion is to delete Nusa Dua?
To delete the Nusa Dua,
Okay.
just use in Bali, Indonesia.
Okay, okay. Thank you. I don't see anyone who disagree with that, so we change that later on. Thank you, sir. So we continue with the second paragraph. Mr. Diouf, if you have anything else, you can also add. Okay? Recalling the Memorandum of Understanding between the AACC and CCGA signed on 9 August 2017 in Surakarta, Indonesia. That's a fact. I don't think there is a problem with that. Okay. Okay. We go to the next paragraph. Recognizing the importance of promoting cooperation between the countries of Asia and Africa based on respect on fundamental human rights in accordance with the purposes and principles of the United Nations Charter, as well as on the equality of all races and the equality of all nations, large and small, as enshrined in the Bandung Declarations in 1955. Any comment? No? Yes?
Oui, président du Conseil constitutionnel de Djibouti.
So I'm the head of the Constitutional Court of Djibouti. I don't see what's the point of writing all nations, large and small. Could we just stop at the equality of all nations? I don't see why we should add large and small.
Thank you, Djibouti. So anyone can go along with the deletions of the large and small? Morocco?
Mr. President, we propose to maintain the wording as it was suggested in this paragraph. We keep the words large and small because it's the same wording that was used in the Bandung Declaration. We should say faithful to the spirit and to the words of the declaration. So we think this wording is a wording that is faithful. Thank you.
Okay. Thank you, Morocco. So I get back to Djibouti if you don't have any.
Monsieur le Président.
Mr. President, all while respecting the proposition of Morocco about this wording in the declaration, because it would correspond to what was said in the Bandung Declaration, I think that the wording should be something dynamic and not just historical. I think that today we would not be speaking about this. It was not the same era. We won't be talking in a legal, document about small and large countries, all nations being equal. I think that, well, I am doubtful about maintaining this idea in the declaration.
Okay. Before I give it to get. So,
excuse me.
Yes.
Yeah.
Turkey.
In response, the many idea about the delete of the large and small in this paragraph. I think because in the end of the paragraph we use the S and Z in the Bandung Declarations. We have to maintain this phrase, I think, because we should to keep the spirit of the Bandung Declaration in this paragraph. Thank you.
Thank you. Yes. Yes, please, Mr. Diop.
Thank you, Mr. President. I think that we would like to stay within the spirit of the Bandung. We must maintain it in the text. This detail about large and small. Maybe to avoid that this debate goes on, we can just remind that this wording was specifically in the Bandung Declaration?
Yes, I also would like to remind everybody that this paragraph is actually has been circulated and being confirmed from the CCGA. I have a request from China. Huh? Ghana, sorry, Ghana, I mean.
No, it's just to say that the statement is self-evident because it says large and small as enshrined in the Bandung Declaration in 1955. So it's self-explanatory. It doesn't warrant a deletion. And then whilst I have the floor, there ought to be a semicolon after 1955.
Okay. Thank you, Ghana. So I believe that everyone could agree with the reflections from the Bandung declarations and the explanation already being put there. So if there's no other delegation, I will take this as a agreement that we stick to the original paragraph. Okay. Thank you very much. So we go to the next paragraph. Expressing our support to citizens in Asian and African countries who seek constitutional justice through the constitutional courts or equivalent institutions. Any comment? Okay. I think we can...
sorry.
Yes?
It's a small thing. It's Zondo from South Africa.
Yes.
I think it should be to citizens of Asian and African countries rather than in.
Okay, two citizens
of
Asian
yeah.
and African countries. Yeah. Thank you, sir. Any other comments? Okay.
Country.
We can take this.
Mr. President.
Yes.
Mr. President, I was just wondering. You can be a citizen in a country, but not of that country, and you still be entitled to seek human rights.
So, what is the suggestions?
In is more inclusive.
Mm.
You can be a citizen in a country, even though you are not Asian or African.
So let me read it again. Expressing our support to citizens in Asian and African or of Asian and African countries. I'm not...
May I?
Sure.
May I say something, Chairperson?
Sure. Yes.
My impression of this, and I'm not saying there can't be another impression or meaning, is that since this is a joint statement of the two associations, Asians and African, we are talking about citizens who are in countries which fall under those associations. And as I understand it, those citizens are citizens in the countries under those associations. That is my understanding, but it is not something that one wants to spend too much time on. If it is felt that it should be in, we shouldn't spend too much time on, but that's my impression.
South Africa?
That was South Africa speaking.
Oh, sorry.
That was South Africa speaking.
Sorry. Okay. I agree with you, sir, that we don't have to spend too much time in these discussions. If Ghana could live with in instead of off, I would much appreciate it. Okay. Morocco?
In fact, the delegation of Morocco considers that the term "in" is more appropriate for the simple reason that it includes the possibility for aliens to access to constitutional justice, especially within the framework of a posteriori mechanisms of constitutional review. And "of" is only exclude aliens to the possibility of aliens to access to constitutional justice mechanisms. "In" is more inclusive in our point of view.
Thank you, Morocco. I think with the explanation from Morocco, then we can agree with the use of "in" this paragraph. Thank you. So let me continue. The next one is reiterating the importance of building shared understanding and enhancing cooperation between the two organizations in the spirit of advancing democracy and the rule of law, protecting the people's or persons' fundamental rights, and ensuring the adherence to the Constitution. No comment? Thank you. Next is appreciating the goodwill of members of the two organizations and their secretariats for the implementations of the Memorandum of Understanding through the organization and active participation in the first AACC-CCGA joint conference. Any comments from the floor? Thank you. Now we go to the operating paragraph. Hereby state the following. The fulfillment of people's fundamental rights is paramount, and the implementation of protective mechanisms has become a necessity. Hence, the establishment of constitutional courts or other institutions bearing similar authorities is inevitable to protect the value of the Constitution, which stipulates the basic rights of citizens. is quite long, but I believe this paragraph has been circulated before the conference. Turkey? Turkey, I mean.
Okay, thank you. I think we should say that human rights are universal, but it is also contextual.
Oh, okay.
Because when you say that point two, when you say that human rights are contextual, I think you are ignoring the importance of universality of human rights. So we better use the word universal as well as contextual. So the conference agreed that human rights are universal and they are also contextual, which must be respected.
Turkey, we have not yet reached that part. I just read the first of the, yeah.
Point two.
Okay, yeah. We haven't reached the point two yet. Okay, but we'll take note on what you have been said. Any comment on the point one? Okay.
Excuse me. From Indonesia. In many documents, we always use the similar with equivalent authorities. Which one better in this document? We still maintain the similar, or we have to change to equivalent authorities? Like equivalent institution in the title of the joint statement, constitutional court and equivalent institution. Why we not change what the similar to equivalent? Yeah, thank you.
I'm not sure about the similar can be used with the equivalent in this type, because equivalent mentioned in the statement is because the name of the organization is like that. In this paragraph, we mention about the authorities that has been given to the courts. So I'm not sure this is part of the. But I would like to learn more from the other delegates, if any. Mr. Diouf, would you like to say something?
Yes, I think, Mr. President, we have always used the term equivalent institution. So this it will be a disorder. You can say that if we don't stick to this expression or this term.
If any other comments, but I don't have any objections with the changing, actually. Okay. Zimbabwe?
Zimbabwe, can I make a comment?
Sure.
Similar is the correct word here, because it refers to jurisdictions. That is the competency not the institutions.
Yeah.
So you can't say equivalent jurisdictions.
Thank you, Zimbabwe. Djibouti, would you like to?
Oui, non,
Yes. Just concerning this, to use the same terms or expression, I think that with if you agree, I would think that it's better to say authority rather than institution, equivalent institution. Mr. President of Djibouti, I think that the expression equivalent, it's already justified. It's to say that is it similar or not, or is it institution, similar institution? It goes to the resemblance or to look like. So, and it means that there are similar functions of the institution. So they have the same competence, or so the expression institution, equivalent institution, it's more right to use this expression, this wording.
Okay. Thank you, Mr. Diouf. Any other?
Yes, Chairperson.
South Africa.
Ghana.
Yes.
South Africa. Once again, I don't think we should spend too much time on this, but it seems to me that as between similar and equivalent, similar seems to refer to type or character or kind, whereas equivalent seems to refer to size or status or weight. So if we use, the original meaning seemed to me to refer to character or kind rather than to status or weight. But in the end, I think whether we use equivalent or similar, somebody will have an idea what we have in mind. But those are my thoughts. If we are talking about authorities, it looks like it should be similar because of the impression I get from the original draft. Thank you.
Thank you, South Africa. Algeria. 2 minutes. Algeria.
Yes, for us, we are for the equivalent institutions. It's more just, or it's more right to use this expression or to use this term.
Thank you, Algeria. Zambia.
Thank you, Mr. Chair. We tend to gravitate towards the proposal from the delegation of Zimbabwe. Our understanding is that when we highlight the term constitutional court or other institution, we are here looking at institutions of similar jurisdiction. I will give you a clear example from my own jurisdiction. Our constitutional does make our constitutional court equivalent to the Supreme Court. However, the two institutions have different mandates or jurisdictions. To place in equivalent may create some difficulty. Similar jurisdiction to us sits well with our own situation. Thank you.
Thank you, Zambia. If there's no, Niger, no,
Si.
yes.
Oui. Oui, merci. Merci, monsieur le...
Thank you, Mr. President. I think that the Professor Duf has said that the best proposition here, but of course the text in we see that it's talking about institutions, equivalent institutions, and in the paragraph, fourth paragraph, of course, we can see that we use institution, equivalent institution. So we cannot, and no, it's after that, we cannot say similar, and we cannot say similar institution. The problem here is it could have a problem of interpretation, because it already in this room among us, if we see the text, we can see that we should use the same expression or terms, similar or equivalent. It's the same, or but the question here is also concerning competence or jurisdiction, or is it concerning other something else? Is it the same jurisdiction? And of course, if we can say there are different ways of there can be same expressions, terms, or not in the text. So, but my position here, I could say that the expression equivalent expression, it's more right to use this term or expression. Thank you, sir.
Thank you, sir. So we have been discussing quite lengthy on this paragraph, especially on the equal institutions, and here using on the paragraph. So if I could take note properly, the proposal is to change the wording at the third line, or other institutions, is changed with the equal institutions, equivalent institutions bearing similar authorities, etc. Is that the correct understanding? Okay. Okay. I don't have any comment on that. So the
comment. It's a comment.
Okay. Okay. We can continue with the point 2 of the paragraph. I think Turkey already proposed to add the universal. So if I read the paragraph, The initial one is the conference agreed that human rights are contextual, which must be respected, promoted, protected, and fulfilled on the considerations of the local wisdom, culture, tradition, and civilization of each country. Therefore, the AACC and CCGA Joint Conference Forum is expected to be a new avenue for collaborative cooperation among constitutional justice bodies, especially to contribute in finding potential solutions to overcome challenges. This paragraph is actually taken from the paper from Professor Arif, both the resource person. So we take some of the words of that. And Turkey is already proposed to add universal human rights are universal as well as contextual. Is that my understanding correct, Turkey?
Well, I think alternatively, we should add adjective universal just before human rights. So we can say universal human rights are also contextual.
Yeah. Okay. Universal human rights are also contextual.
Are also contextual.
Okay. Any comment with the additional words from Turkey?
Yep.
Zambia?
Ghana?
Thank you. We seem to have difficulty with the word contextual with universal already in place. Because immediately once we say these standards are universal, they create a minimum that cuts across all civilizations. Now, when it comes to contextual, are we watering down that universal minimum standard? Just some guidance on that.
Okay. Noted, Zambia. Indonesia? Yes. Yes, Indonesia.
Yeah, thank you. Actually, I don't know related praise or words local wisdom, culture, and tradition. I hesitated that praise can get redundancy. Therefore, how if we can one praise or others in order we can get certainty between wisdom, local wisdom, culture or tradition. I think same thing, yeah, same thing meaning, yeah. Thank you very much.
Thank you, Indonesia. But I believe this word is actually taken from Professor Arif paper. So we'll see whether this can be done after that. Can we comment on the proposal from Turkey first? Right, yes. I understand.
Ghana?
Ghana?
Yes.
Yes, sir.
I think that the professor's proposal, the professor's text is deliberate, which is that we all are familiar with the concept of universal human rights. The argument of the professor is that notwithstanding the universality of human rights, those rights are also contextual, subject to local wisdom, culture, tradition, and civilizations of each country. And that's a legitimate jurisprudential argument. So the compromise will be to insert universal before human rights and still retain the notion that when it comes to African countries, Asian countries, if you, our traditions, wisdom, and culture in some ways vary from Western sense of the same notion of right. And that's the argument the professor makes, and is the reason why the text appears the way it is. But I agree that the compromise will be to insert Turkey before universal human rights, but which are also contextual and subject to local culture, wisdom, tradition, and civilization of each country. Thank you.
Thank you, sir. Yes, Mr. Duke.
Je vous remercie, Monsieur le Président. Je crois que la
Thank you. Thank you, Mr. President. I think context of these rights is of course important. I'm saying it again because we can see that universal, but we are looking, sometimes we're looking at imposing things. So it's not, it shouldn't be this way. It should, we should look at the context, of course, and so I think that when we talk about context, it's important. We have to see the context, contextual. So it should be contextual. Would it be in Africa or in Asia? So it's always contextual. Okay.
Me?
شكرا. إذا أردنا أن نبقى في إذا أردنا أن نبقى في نفس المنهج نتاع فكر باندونغ نتاع 55 وحتى نحافظ على
So holding steadfast to the thinking of our forefathers in Bandung, therefore, we must adopt the phrase human rights and the states. Thank you.
Is Djibouti?
Oui.
Yes, yes, sir.
Merci, Monsieur le Président.
Thank you. Okay. Thank you. Allow me to say that say things about this paragraph. First of all, the first point, to see the principle of human rights that are universal, and then I don't know, but and then there's another point that we're highlighting the context also of each country, each one of our countries regarding this human rights that are universal. When we say universal, it can be limited to contextual. It can refer to contextual items, so contextual in each country. So that's what I would like to propose, Mr. President.
Thank you, sir.
Okay.
I've been reminding by the organizing again and again about the time, but I'll give it to Morocco and then Mozambique after that. Morocco, you have the floor.
Merci, Monsieur le Président.
Thank you, Mr. President. We are we agree with a delegation from Turkey and also other delegation concerning the wording contextual and first of all with the text and also the text of the United Nations, universal human rights that are universal, that are also diverse, and we should look at the diversity and also concerning protection of human rights, because of course this is our comprehension of human rights. We have to, and Morocco has also recognized that all the countries here that universal human rights that are universal, but I think that universal, we can say it's more right to use, of course, universal.
Okay, thank you, Mark.
Yes, merci.
Can I have Mozambique? No?
Muito obrigado. Queria cumprimentar a
Thank you very much. I would like to build up on what was mentioned previously. I would also like to contribute to point number 2, because it wants to enshrine 2 perspectives of views in regards to human rights, which is the universality of human rights and also the relative aspect of it. And universality has to do with the fact that human rights are equal to all human beings. But when you talk about the relative aspect, has to do with respecting cultures. So what do we propose? What does Mozambique proposes is to reconceptualize this view, looking at human rights as multicultural, to respect those who advocate for universalism, as well as those who see human rights from a cultural perspective of each peoples when it comes to this case of human rights. Thank you very much.
I will have
last one.
Only Madagascar,
Okay.
and after that I will conclude this paragraph. Madagascar. Microphone.
Merci, Monsieur le Président.
Thank you, Mr. President. I'm the President of the Constitutional Court of Madagascar. I think the adjective contextual and universal, they are in complementing each other. Contextual simply means that there is differences in human rights between countries and differences also in time. Universal, I think we should also keep the adjective universal, because even the fundamental text says that the Universal Declaration of Human Rights. So when we have this, when we're talking about universal, this is something ideal for human rights. They might be different, but ideally, we should have universal human rights for all countries. Thank you very much.
To all the delegates now, and I believe that most of us agree with the proposal from Turkey that we put the word universal before the human rights. but we also keep the contextual here. So the first line should be: the conference agreed that universal human rights are also contextual and Arif, you would like to say something? So let me read it first. The conference agreed that human rights are universal and are also contextual, which must be respected, promoted, protected, etc. Is that the case? Can everybody live with that paragraph? Thank you.
Should we, sorry.
Yes.
Should we retain which?
Yes.
It doesn't make sense
Sure,
to
sure.
say
Of course.
they are
Yeah, yeah.
contextual, which
Which must
must be. We should say they are contextual and must be respected.
Of course, sir. I agree with you. Okay.
Chairman, is it okay to put it the final version of the second point in the list? Then we can read it together.
Okay.
The conference agreed that, next,
Human rights are universal.
Human rights are universal
and also contextual.
It is that human rights are universal and also contextual.
Yeah.
That's,
human rights are universal.
Okay.
And also contextual.
Yeah. Must be
and
respect.
Must be respected directly.
Directly.
Yep.
Okay.
Promoted, protected,
fulfill the consideration of the local wisdom.
Local wisdom, culture, tradition, and civilization.
What about the idea? Sorry. The idea of our delegates about the two only use the single word. We can choose culture, or local wisdom, or tradition. We think the culture is quite general, of the local, of the culture or local culture of each country.
So the suggestion is?
Only culture.
Let's maintain the text. It gives you a broader scope.
Can everybody live with only culture?
Oh, let's maintain the text.
Bisa diganti teksnya, coba.
Can we try changing the text?
Considerations of culture and civilization of each country. Can that be approved? Okay, adopted. We go to the next one. Point 3. The conference further agreed that the principle of equality of all races and nations large and small, as prescribed by Bandung Declaration, is the core concept behind the idea of universal human rights, which must be protected by constitutional courts to ensure a just political order at both national and international levels. Comment? I I don't see one. Yes, at the back. Sorry, I can see your
comment.
Thank you so much. My comment is to include an equivalent institutions, not only constitutional courts. What I mean is, must be protected by constitutional courts and equivalent institutions.
Okay. I think that's fair. Okay. So we put after the constitutional courts and equivalent institutions to ensure a just political order at both national and international levels. Okay? Thank you. So it leaves us only another two. I think this is much easier. So point number 4 is appreciate the Permanent Secretariat of the AACC for planning and coordination in Indonesia, and the Permanent Secretariat of the CCGA in Algeria for the successful convening of the first AACC-CCGA Joint Conference on 4th October 2022 in Bali, Indonesia. No comment?
I have small things.
Sure.
Before move to the next paragraph.
Mm-hmm.
I find the institution body in the paragraph 2.
Mm-hmm.
What is institution body? Justice bodies. Is it okay to change to institutions?
I don't have any problem with that.
Yeah, because we already used institution in all texts. Yeah.
Okay.
Thank you.
We will we'll rewrite that part. Paragraph 2, right? Okay. Thank you. So no comment on paragraph 4?
There is comment, South Africa.
Oh, okay. Please,
I think there is the issue that I want to comment on is common to both point 4 and point 5.
Mm-hmm.
All the previous paragraphs start with subjects, whereas 4 and 5 start with verbs.
Okay.
In 4, it starts with appreciate.
Mm-hmm.
So I think it should be changed maybe to the conference, and maybe either expresses its appreciation to the Permanent Secretariat, blah, 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 or we say the conference commends the Permanent Secretariat, blah, 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 for the successful convening, blah, 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 blah. But as it stands, starting with a verb, it is not correct. And when we come to 5, we might have to do the same.
Okay, sir. I agree with you. Morocco, you have a floor. Morocco?
Just a technical proposal concerning the second paragraph. We propose to delete contextual because it's repeated, the word contextual in the second paragraph, second line in the second paragraph, and also contextual. The word contextual is repeated, and to delete which. Contextual, and to delete which.
Okay, it should be corrected. Yes, yes, it will be corrected, sir. So I agree with the proposal by South Africa to start the beginning of the
paragraph 4 and 5 with the conference. Maybe we can use commend. So the conference commend the Permanent Secretariat of AACC and the Permanent Secretariat of CCGA and etc. And number 5 should be start with the conference as well. The conference launched a call for applications for the holding of the second joint AACC and CCGA conference in 2025 in the member countries of CCGA. Is that okay with everyone?
South Africa, again.
Yes, sir.
In regard to paragraph 5, I would suggest not using the word launch, but say conference, either say conference calls for applications or conference invites applications.
Okay.
Thank you.
Agree with you, sir. So we could use invite actually. Thailand? I have Thailand on my list.
Thank
You
you.
have- thank you.
Can we get back to point number 3? The first adjust political order. We just wondering the sense or the scope of the meaning of this first political order. Could you please clarify that, please?
Before Thailand, going back to paragraph 3 and asking about the just political order, can we agree first on the paragraph 4 and 5? I don't see any problem with that. We just add what has been mentioned by the distinguished delegates of South Africa. Okay?
But however, well, we just would like
Sure.
to know the sense of the meaning.
Sure. No, I will give it back to Thailand because this wording is coming from the paper that has been read by, I think it's on the sub-team 2 previously. So if we could agree on the 4 and 5, so we can back to the questions of what has been asked by Thailand. So I believe this the nuance of just political order is what the Constitutional Court and the equivalent other institutions do within their constitutional mandate when there is if I understood correctly from the paper, what has been done by the Constitutional Court is actually have a strong lead when there is a problem within the country. So they have this power and mandate to put back political stability in their respective countries. This is what I understand from the sub-team 2 paper. Is that sufficient for Thailand? But I believe that we could also discuss about this nuance or statement and see back on the paper of the sub-team too. Okay. Okay. Honorable judges, the distinguished participants and delegates, that will conclude our discussions now, and we will correct it, all the typos and other insertion that is needed based on your assessment now. And for that, I really thank you and highly appreciate your comments and suggestions on this joint statement. The joint statement, the corrected or the revision of the joint statement will be circulated later by the Secretariat, I believe. There will be contact persons for that. And in this regard, I would also like to thank Monsieur Diouf from Senegal for his company in this table, and have a good lunch today. Thank you very much.
Right, thank you, Mr. Diouf and Mr. Purnomo. Ladies and gentlemen, right, please remain seated. Thank you. Right, now let's move to our agenda. I will invite the President of AACC, His Excellency Chinbat Namgil, to give his remarks.
Эрхмөндөд ерөнхийлөгч дарга нараа хүнд зочтой атгатай ноёдоо та бүхэнд өнөөдрийн мэнд хүргэж байна. Юуны өмнө 2017 онд үндсэн хуулийн шүүх түүнтэй адил байгууллагуудын Азийн нийгэмлэг болон Африкийн үндсэн хуулийн шүүх эрх мэдлийн байгууллагуудын баг хурд хооронд байгуулсан хамтын ажиллагааны санал бичгийн хүрээнд анх удаа хамтарсан баг хурд амжилттай зохион байгуулж хамтын ажиллагаа тогтсон байгаад үндсэн хуулийн шүүх түүнтэй ажиллах байгууллагуудын Азийн нийгэмлэгийн ерөнхийлөгчөд бүгд найрамдах Индонези улсын үндсэн хуулийн шүүхэд гүн талархал илэрхийлж байна. Энэхүү баг хурд нь Африкийн үндсэн хуулийн шүүх эрх мэдлийн байгууллагуудын баг хурдтай хамтран ажиллах олон төрөл хэлбэрийн нэг өгөөд энэ удаад үндсэн хуулийн шүүхийн харьяалал ба үндсэн эрхийг хамгаалах Африкасын харьцуулт болон Аз-Африк дэх бүх хүмүүс гарлын төснүүдийн тэгш байдлын тухай бандунгийн зарчмуудыг хэрэгжүүлэх сэдвийн хүрээнд сонирхолтой илтгэлүүд тавигдаж үндсэн хуулийн эрх зүйн чухал асуудлуудыг хөндөж харилцсан мэдээлэл солилцсонд баяртай байна. Арчуулгын зэно. Аливаа нийгэмлэг холбоо нь гишүүн орнуудынхаа нэгдсэн санал бодлыг илэрхийлэгч нь байдаг юм а. Өнөөдрийн баг хурлын үр дүнд батлагдсан хамтарсан мэдээлэл нь үндсэн хуулийн шүүх түүнтэй адилах байгууллагуудын Азийн нийгэмлэг болон Африкийн үндсэн хуулийн шүүх эрх мэдлийн байгууллагуудын баг хурал хоорондын хамтын ажиллагааг улам бүр баттгсан баримтчиг болсон төдийгүй Aacc TV-ийн найрсаг хамтын ажиллагааг улам бүр өргөжүүлэн хөгжүүлэхэд чухал ач холбогдолтой юм а. Цаашид хамтарсан судалгаа, сургалт, семинар болон бусад асуудлуудыг хамтран зохион байгуулж хамтын ажиллагааны хүрээгээ улам бүр тэлгэд бид баяртай болно. Өнөөдөр илтгэл тавьж хурал идэвхтэй оролцсон та бүхэн болон орчуулагч нартаа талархал илэрхийлж цаашдын амжилт хүсье өрөөж байна. Баярлалаа.
Excuse me, there wasn't the English interpretation, so I'll just read the Mr. President's remarks in English now. Your Excellencies, distinguished guests, ladies and gentlemen, I would like to greet you and wish you all to have a pleasant day. First of all, I would like to express my deep gratitude to the Constitutional Court of the Republic of Indonesia and its staff for successfully organizing the first joint conference and initiating the cooperation within the framework of the Memorandum of Understanding between the Aacc and the CCGA signed in 2017. This conference is one of the many types and forms of cooperation with the Conference of Constitutional Jurisdictions of Africa. This time, I'm delighted that interesting presentations were made under the themes Constitutional Jurisdictions and Protection of Fundamental Rights, Cross-Looks from Africa and Asia, and Actuating the Bandung Principles of Equality of all people, races and nations in Asia and Africa. Important legal issues of the Constitution were discussed and information was exchanged mutually. Generally, associations represent the unanimity of its members. Therefore, the joint statement, which will be approved as a result of today's conference, is not only a document that further strengthens the cooperation between the Aacc and the CCGA, but it is also important for the further expansion and strengthening of friendly relations between Asia and Africa. In the future, we are looking forward to expand our cooperation by organizing joint research, training, seminars, and other conferences. I would like to express my gratitude to all of you who gave speeches and actively participated in today's conference, and the interpreters, and wish you all success in your future endeavors. Thank you.
Thank you very much, His Excellency Chinbat Namgil. Next, we will hear remarks from the President of CCGA, Her Excellency Laurinda Prezeres Montero Cardoso. Please, ma'am.
Boa tarde a todos. Venerando juiz, conselheiro, presidente do Tribunal Constitucional da Indonésia.
Good afternoon, Honorable President of the Asian Conference, Asian Constitutional Courts and Equivalent Institution, and President of the members of CCJA, President and representative of the Venice Commission, judges and counselors of constitutional courts, and members of Aacc and CCJA, distinguished members of the present delegations, ladies and gentlemen. We have reached the end of the first joint conference between the Asian Constitutional Courts and Equivalent Institutions and the Conference of Constitutional Jurisdictions of Africa. Please allow us, before all, to express on behalf of the association to which I am a president, that today has 47 courts, our gratitude to the Indonesian Constitutional Court and the Association of Asian Constitutional Courts and Equivalent Institution for organizing this conference that will be marked in history and will make the relationship between our two regional groups stronger. As very well highlighted here, the Asian-African cooperation has legal marks, indelible ones. The Bandung Declaration of 1955 that resulted from the Asia-Africa Conference held in the city of the Republic of Indonesia, country that once again hosts this conference, constitutes a ballast for this declaration. The Declaration of Bandung establishes in a very clear way the commitment of the member states of promoting peace and the cooperation, as well as its support to the fundamental rights in human rights established in the UN Charter and the defense of the universal human rights. We are in agreement with the notes that have been reached in this session that the matters inherent to human rights have to respect the principles and realities when it comes to social, cultural aspects of each country. The respect for fundamental freedoms must be constitutionally respected, as well as human rights in general have to be the limit of any and every society. We also highlighted the element of the respect of equality as a principle, and we express our request for all efforts to be made in the sense of mitigating, eliminating discrimination based on gender. We are convinced that the information interchange, as well as experience and ideas interchanged amongst our constitutional jurisdictions, characterized by a huge cultural diversity, but that share a common background of being subjected to colonialism. This conference was very productive, and it's going to contribute to the strengthening of our institutions and enriching of our decisions as guardians of human rights and the constitution of the respective countries. So, we have to congratulate all the speakers for the quality of their presentations, as well as the moderators that were here in this session and the entire team of the Indonesian Constitutional Court and AACC for the amazing work done in organizing this conference. So it is shown the undeniable potential of interchange between AACC and CCJA, and therefore it is mandatory for us to keep on strengthening the relationship between the two groups, given the signing of the Memorandum of Understanding that was signed in 2017. There's a huge challenge on the hands of the jurisdictions and African constitutions that will organize the next joint conference that shall have the collaboration of all the members beyond the General Secretariat to guarantee a successful taking place as the example of this first joint conference. So to wrap up, we reiterate our thanks to all the members and delegations, to the General Secretariat of AACC and CCJA for your attendance and the active participation in the work. Thank you very much.
Thank you, Her Excellency Lorinda Prezeres Monteiro Cardoso. Next, we will hear closing remarks and also to pronounce the AACC-CCJA joint statement by Constitutional Justice of the Constitutional Court of the Republic of Indonesia, His Excellency Saldi Isra.
The Honorable distinguished guests, ladies and gentlemen, it is a great honor for me to deliver joint statement as the end of our meeting today. Joint statement, the first joint conference on the Association of Asian Constitutional Courts and Equivalent Institutions, AACC, and the Conference of Constitutional Jurisdictions of Africa, CCJA. Bali, Indonesia, October 4th, 2022. We, 39 member jurisdictions of the Association of Asian Constitutional Courts and Equivalent Institutions, AACC, and the Conference of the Constitutional Jurisdictions of Africa, CCGA, gathered at the first AACC-CCGA joint conference under the theme of promoting Asian-African cooperation for the protections of people's fundamental rights on 4 October 2022 in Bali, Indonesia. Recalling the Memorandum of Understanding between the AACC and CCGA signed on 9 August 2017 in Surakarta, Indonesia. Recognizing the importance of promoting cooperation between the countries of Asia and Africa based on respect for fundamental human rights in accordance with the purposes and principles of the United Nations Charter, as well as on the equality for all races and the equality all nations, large and small, as signed in the Bandung Declaration in the 1955. Expressing our support to citizens in Asian and African countries who seek constitutional justice through the constitutional courts or equivalent institutions. Reiterating the importance of building shared understanding and enhancing cooperation between two organizations in the spirit of advancing democracy and the rule of law, protecting the people's or persons' fundamental rights, and ensuring the adherence to the Constitution. Appreciating the goodwill of members of the two organizations and their secretariats for the implementation of the Memorandum of Understanding through the organization and active participation in the first AACC-CCGA joint conference. Hereby state the following. First, the fulfillment of people's fundamental rights is paramount, and the implementation of protection mechanisms has become a necessity. Hence, the establishment of constitutional courts or equivalent institutions bearing similar authorities is inevitable to protect the value of the constitutions, which stipulates the basic rights of citizens. Second, the conference agreed that human rights are universal and also contextual and must be respected, promoted, protected, and fulfilled on the consideration of the culture of each country. The AACC and CCGA Joint Conference Forum is also expected to be a new avenue for collaborative cooperations among constitutional institutions, especially to contribute in finding potential solutions to overcome challenges. Third, The conference further agreed that the principle of equality of all races and nations large and small, as prescribed by the Bandung Declaration, is the core concept behind the idea of universal human rights, which must be protected by constitutional courts and equivalent institutions to ensure a just political order at both national and international levels. Fourth, the conference commended the Permanent Secretariat at the Aacc for planning and coordination in Indonesia and the Permanent Secretariat of the CCGA in Algeria for the successful convening of the first Aacc-CCGA Joint Conference on 4 October 2022 in Bali, Indonesia. The last, the conference invites applications for the holding of the second joint Aacc-CCGA conference in 2025 in a member country of the CCGA, done at Bali, Indonesia on October 4th, 2022. Thank you very much.
Thank you, His Excellency Professor Saldi Isra. Right, ladies and gentlemen, we almost reach our closing of our event. After lunch, there will be provided, just to inform you, ladies and gentlemen, that after lunch, there will be regional meetings for Aacc on 2 p.m. 2:15 p.m. at Nusa Dua Hall 4, located downstairs on the first floor, and also group meetings for CCJA on 4 p.m. in this room, in the same room, at Singaraja Hall 2. And also after this event, we will provide lunch that will be provided at Foyer Singaraja and Foyer Kintamani. And before we close this event, I would like to inform you that all delegates, the head of delegates, will be asked to join on the stage to take a group photo. And prior to the group photo, I will ask the president of Aacc, His Excellency Jinbat Namjil, and also the president of CCJA, Her Excellency Lorinda Prazeres Montero Cardoso, to join together on the stage to do a souvenir exchange. Yes, please, sir. And madam.
Recording stopped. Recording stopped.
And after this, I would like also to ask a moment, sir. A moment, sir. We need to, yes, to do souvenir exchange first. Yeah. With the two presidents of the associations. And also I would ask to invite Mr. Musa Laraba, Permanent Secretary General of CCJA, and Mr. Guntur Hamza, Head of AACC Permanent Secretariat for
Recording in
Planning and
progress.
Coordination
Recording in progress.
to do a souvenir exchange as well.
Recording stopped. Recording stopped. Recording in progress.
Right, and the next souvenir exchange between Mr. Musa Laraba and Mr. Guntur Hamza. Right, once again, this is a souvenir exchange between Mr. Musa Laraba and Mr. Guntur Hamza, and also from His Excellency Chinbat Namgil and Her Excellency Lorinda Prazeres Montero Cardoso. Let's take a photo once again, ladies and gentlemen, on the stage, right? Here we go. Thank you. Thank you, and all head of delegates can also join on the stage to take a photo group session. Right, if everyone is ready, on my count. We are still waiting for another head of delegates to join on stage to take a group photo. Right, a moment. Yes, a moment, please. Ladies and gentlemen, we are still waiting for another delegate to join on stage. If anyone is ready, ladies and gentlemen, on my count, in 3, 2, 1. One more time. 3, 2, 1. Is that okay? Photographers, videographers? Right, one more time. In 3, 2, 1. Right, thank you, Excellencies, ladies and gentlemen, to all head of delegates to participate on a group photo. Thank you once again. And Excellencies, distinguished delegates, ladies and gentlemen, to conclude our event and to close our event, there is saying in Bahasa Indonesia, we say it, ada perjumpaan, maka ada perpisahan, which means when there is a meeting, then there will be a goodbye. I am certain that you are looking forward to our agenda tomorrow, and on behalf of the Constitutional Court of Republic of Indonesia and all of the committee in charge during the Aacc CCJA conference, joint conference, we thank you once again for your participation and wishing that you enjoy your stay in our lovely island of Bali as well as our conference. I am Wahyu Wiwoho, signing out. Experience wonderful Indonesia and have a pleasant stay and journey in Bali.